Hi, everyone. Welcome. Is this working? The light is on. Is it getting better? I really need to lean into this that much? Okay. All right, I will. Welcome. I'm Alice Madden. I'm the director of the Getches-Wilkinson Center for Natural Resources, Energy, and the Environment. So welcome to tonight's event. I want to start out by thanking Alyssa Joel from the Center for Climate Integrity. Alyssa approached us a while back about doing this panel here tonight. She and her colleagues really put it together. She herself could not be here, which is unfortunate, but they were just instrumental in really pulling everything together for the event. Union of Concerned Scientists is also a co-sponsor, so please help me thank them for this hard work they did. And I'm excited, we always record events here, but I'm excited to say that we're live streaming. And we have an audience at the University of Hawaii because their environmental law program will be hosting something very similar, and they wanted to see what we do tonight. So let's all say aloha. And think about that just for a moment. So although we're largely just physically hosting the event tonight, I want to tell you a little bit about the Getches-Wilkinson Center. We regularly convene diverse sets of thought leaders, practitioners to address the most pressing issues of the day, and that can cover public lands, water, energy, tribal resources, environmental justice, and climate change, as we are tonight. The center is a large part of the reason why Colorado is rated one of the best environmental programs in the entire country. So we all know that there's a lot of ways you can address climate change. You all here tonight, which probably means you take a lot of your personal actions to try to do that as well. There's been an increase in renewable energy, energy efficiency, and advances in clean technologies, local, state, federal laws, international treaties, and tonight we're going to talk about a different method, which is climate litigation. Environmental lawsuits generally have a long history of forcing protections and safeguards and sometimes becoming the basis of a change in law. Most recently here in Colorado, a lot of you probably heard about the Martinez case. The Colorado legislature just passed a bill, among other things, to clarify the intent of oil and gas regulations after a ruling by the Supreme Court. So I know some of you are familiar with a case called the Juliana case. And I mention that because one of the plaintiffs is from Boulder, Colorado. But that was a case by a group of 21 youth who sued the United States government under what's called a public trust doctrine. And they said the government was allowing, oops, sorry, my notes got out of place here, was allowing activities that significantly harmed their right to life and liberty. And the government must adopt methods to reduce greenhouse gases. A district court held that their access to a clean environment was a fundamental right. So that case is ongoing. I think the next hearing is in June. Tonight we're focusing on a very different approach where local governments have sued private fossil fuel companies under a public nuisance theory and others that you'll hear more about. I think it's a relatively new claim. Is that fair to say? Applied in this circumstance? Well, we'll hear more about it, of course. And so tonight we're going to focus on those types of cases, but particularly cases filed by the City of Boulder, Boulder County, and San Miguel County. So on to our panel. It's my pleasure to introduce our dean. And just so you know, I have greatly shortened the folks' bios tonight, especially the deans, and it's hard when you do that for your boss. So. But Dean Anaya has taught and written extensively on international, excuse me, I'm messed up all my papers, on international human rights and issues concerning Indigenous peoples. He's lectured around the world. He was a United Nations Special Rapporteur on the rights of Indigenous people, where he monitored human rights conditions and promoted practical measures to address any abuses and secure their rights. He participated in the drafting of the United Nations Declaration on the Rights of Indigenous Peoples. He's also the author of numerous books. He served on the law faculty at University of Arizona, the University of Iowa, has been a visiting professor at many universities, including Harvard Law. Prior to becoming a law professor, Dean Anaya practiced law in Albuquerque, where he represented Native American peoples, among other minority groups. So on to the rest of our panel. I'm going to introduce them in the order that they'll be speaking tonight. Brenda Eckwurzel is a senior scientist and director of climate science at the Union of Concerned Scientists. UCS is a national nonprofit organization that combines rigorous independent science with advocacy to solve the world's most pressing problems that are at the forefront of national efforts to understand the challenges posed by climate change, and they work to advocate change. She herself is an expert on the influence that major carbon producers have had on rising temperatures and sea level. She's also a co-author of the 4th National Climate Assessment, Volume 2. Next, we have John Golden Dubois, who's the president of Western Resource Advocates, our neighbors across the street. WRA is a leader in efforts to shift Colorado and other Western states toward cleaner energy, water, and air. John's been president of WRA since 2014, and he's been an innovator and a strategic leader within the nonprofit community for over 30 years. Next is Marco Simons. He's general counsel of Earth Rights International, an environmental and human rights nonprofit organization based in DC. In addition to cases like tonight's, Marco oversees a number of cases focusing on protecting communities' human rights and the environment. He's served as counsel on major transactional corporate accountability cases, which have used the Alien Tort Statute and other strategies to hold corporations accountable for overseas human rights abuses. And last, we have David Bookbinder. He's the chief counsel of Niskanen, did I say it right?
Yes, Niskanen, very good.
Center, a nonprofit libertarian think tank based in DC. He has decades of experience litigating high-profile cases, including dozens of cases under all of the major environmental statutes, and several cases before the U.S. Supreme Court. He is co-counsel, also representing the litigants we'll be talking about tonight. So I'm going to hand this over to Dean Anaya, and thank you again, Dean, and thank you all for being here.
Thank you all for coming, and thank you, Alice, for that introduction. It's a real treat for us to have this distinguished panel who are at the front end of some important litigation, whichever side of the issue you're on. It is important litigation, and hopefully we'll bring out all sides, both sides of litigation in one way or another. Let's start by allowing each one, or calling on each one to give their opening remarks. So, Brenda?
Thank you. Thank you all for taking time this evening to talk about some of these interesting topics from my perspective. So I am looking at the advances that are represented in the 4th National Climate Assessment, Volume 2, that was released just after Thanksgiving. And one of the two major advances since the 3rd National Climate Assessment is that extreme event attribution to the causes and links to climate change, extreme events that are happening in the United States, has improved and has advanced. So that's one of the major advances. The other thing is that on the chapter that I was co-author with my colleagues, there was a multi-sectoral economic analysis of what global emissions mean for direct damages to the US economy. So we also cataloged all the great work that states such as Colorado, cities such as Boulder are doing. So we cataloged over 455 cities in the United States are taking actions, and all states, including Puerto Rico and US Virgin Islands, are taking actions. And we were looking at 30 different types. However, what is really important is to think about some of the attribution science, I think, that relates to some of the impacts that Coloradans have to adapt to, even if we were to go to zero emissions tomorrow. Because we've dialed in a temperature, and the whole world has decided we're going to do the Paris Climate Agreement. We're working towards that, so we likely would expect that we might have another half a degree to a degree Celsius warming, or if you want to look at that in terms of Fahrenheit, we are at 1.8 degrees Fahrenheit. We might go another 1.8 degrees Fahrenheit warmer in the global mean surface temperature. So what we see is that, for example, wildfires has been one of the impacts. You may recall Waldo Canyon, other types of fires, and hotshots are putting their lives at risk to protect your properties and homes. So one of the findings in that assessment is that from 1980 to today, nearly half of the cumulative forest acres burned, would not have been burned were it not for the level of climate change we have. Just one other attribution statement I'll show you is that between the year 2000 and 2014, the Colorado River flow has had record reductions in flow. And the attribution is between 17 and 50% of that record-breaking reduction in flow can be attributed to the warming in this region that increases evapotranspiration, water loss from plants, and so forth, and that's linked to climate change. So I can talk more later. I'm sure the Dean has many questions for us, but I'll hand it back to my esteemed colleagues here on the panel. Thank you.
Thank you, Brenda.
All right. I think to do these slides, it might work better from here. So I think they're going to put the screen down. That's what I've heard.
No.
We'll just wait for that screen to come down. There we go. All right. Again, my name's John Golden Dubois, and I'm the president of Western Resource Advocates. We are located just catty-corner from the law school here. And Western Resource Advocates works across 7 western states to protect land, air, and water so that we have vibrant communities that are in balance with nature. And we do that through 4 different program areas, including our work on climate and clean energy, healthy rivers. Oh, good. It's coming up. Okay. Healthy rivers, clean air and clean water, and also through the protection and connection of western lands. I've been asked to talk a little bit about what is happening around the region, both in terms of some of the impacts that we've seen and in terms of what's happening to address climate issues outside of the lawsuits that we're talking about here today. So the big picture, Brenda already addressed some of this. The Intergovernmental Panel on Climate Change says that human-caused global warming will continue up to about 0.5 degrees Celsius to 1 degree Celsius if we stop emitting carbon emissions and carbon emission equivalents today. So if we get to zero global emissions right now, the damages will have already been baked in, but they won't be nearly as severe as they would be if we get to increased levels of temperatures around the world. Our goal is to hold temperatures to between 1.5 and 2 degrees Celsius. That's the goal of Paris. In order to get to that, the best science tells us that, in order to get there, we need to see carbon reductions on the order of about 50% by 2030 and at least 80% by 2050. Perhaps we really need to be at net zero by 2050. So we got a lot more to do. The panel had stated in previous reports that we're going to be a lot better off at 1.5 degrees than at 2 degrees. So getting to zero emissions by 2050 is pretty important. The IPCC has been really clear, though, that climate change is already impacting us. Brenda talked a little bit about this. They state that many land and ocean ecosystems and some of the services they provide have already changed due to global warming. So we obviously have to get started right now. There's a global imperative. Yes, communities are acting, but that doesn't change the fact that what's happening has already been demonstrated. Things like this, just one of several major hurricanes from 2017. The IPCC tells us that at 2 degrees Celsius rise in temperature, we get substantially increased risks for these types of activities across the globe. Major damaging hurricanes. Consistent with that, of course, is also what we'd expect, increased risk of heavy precipitation events like this one. This, again, is just one of the many major events that took place in 2017 where millions of people were evacuated, hundreds of thousands lost everything that they own, and dozens of people lost their lives. Cost of these events just in that one hurricane season alone was about $500 billion. The 4th National Climate Assessment, which Brenda also mentioned, talks a little bit, which is a report of 13 federal agencies that essentially suggests that we have about 11 years to make the emission cuts that we need to get on the trajectory to limit carbon emissions, to limit those rises in temperature to 1.5 to 2 degrees. So if we hope to avert things like increasing in multi-decadal drought, which impacts both our food and our water supply, we need to act expeditiously. So changes in temperature and precipitation are increasing air quality risks, health risks from things like wildfire around the region, from ground level ozone pollution. Closer to home, this was one of about 80 wildfires that was burning last summer across the West. Over 8 million acres of land were burned. And of course, this is Santa Rosa. Estimating what the cost of this is hard to do. You can probably estimate some of the economic costs, but if you look in terms of human lives and you look at how people's lives have been changed. So the National Climate Assessment said that rising temperatures, extreme heat, drought, wildfire on rangelands, and heavy downpours are expected to increasingly disrupt agricultural productivity in the United States. This is one of several fires that has taken place over the last few years right here in Boulder County. The 4 Mile Canyon fire in 2010 burned 168 homes, or about $217 million in damages, about an additional $14 million to fight the fire itself. The Cold Spring fire in 2016 cost another $1.5 to $2 million. So we can see the impacts. This next slide will be very familiar to you all and close to home. The 2013 floods here in Boulder, 8 lives were lost, about $3 billion this cost. To put this in perspective, the city of Boulder's budget is about $350 million annually. So you can see pretty substantial economic impact. And all of these climate impacts are consistent with what the best science is predicting. If you just look at the Colorado River system as one example, Brenda talked a little bit about this. This is a river that supplies water to 2 countries, 7 states, 40 million people across the western United States, irrigating 4 million acres of farmland, drives the economy and people to 5 national parks. It's home to a variety of species, both in the river and outside of the river, and the predictions are that the river will have up to 35% less water in it due to climate change. So what cost is that? Well, if you just look at the recreation sector alone, $26 billion is the annual value of recreation along the Colorado River, just recreation alone. So we're talking billions and billions of dollars of economic impact. So what should we do? Well, we have to do everything, including the topic we're here to talk about tonight. Western Resource Advocates' role is in focusing on the electricity sector. What we do is we develop policies that drive changes to reduce carbon emissions in that sector, because not only is this sector the largest emitter of carbon emissions in our region, but by decarbonizing the electricity sector, you also get advantages when we decarbonize the transportation sector, when we electrify home heating and cooling as well. So provide some real opportunities. There are a ton of things happening in Colorado right now. There are 5 bills in the state legislature that should all be heard within the next 2 days within the legislative session. There's a bill that sets a carbon emission goal for the state of Colorado, reducing carbon emission goal for the state across the whole of the economy. There's a bill that would ensure that the social cost of carbon is incorporated into all utility planning in the state. So we have to do everything and more. We have to ensure that we advance low emission vehicle and zero emission vehicle standards here and around the region. We have to electrify buildings. We have to use soil and agriculture in smarter ways to sequester carbon. And we have to drive reluctant, sometimes recalcitrant, and responsible industries and those sectors to change through policy, through incentives, and where necessary, to hold them accountable for the tremendous costs that they will cost us. This is the topic going forward tonight, so I'll stop there.
Thank you, John. Now we'll hear from Marco.
Great. This is great. Brenda and John have given a great overview of the impacts locally and the full range of activities that are needed. I'm going to talk about the litigation here, which is addressing only one small part of this broad picture, which is specifically the adaptation and resiliency costs that these communities are facing in the coming years. It was interesting around the law school building. I've seen these little stickers that urge people to turn off lights and report leaky faucets and stuff, suggesting that you can turn off climate change. And I love the messaging that we all have a part to play and every little bit counts. But part of the reason we're here is that for a lot of what's happening now, it can't be turned off, in the sense that there's a lot of warming that's already happened and will continue to happen regardless, even if full decarbonization happens tomorrow. And so regardless of what happens on all of these policy fronts that John is rightly emphasizing, these communities are facing serious costs for adaptation, and somebody needs to pay for them. And that's either going to be you, as the taxpayers of these communities, or other responsible parties. So I'm going to talk a little bit about why we think that these defendants, the oil companies that we have sued, are appropriately responsible for at least part of the costs facing these communities. And certainly the oil companies have played a huge role in producing the products that are primarily responsible for the climate change. There's no debate about that. But that's not the only reason that they're responsible. A big part of this is the degree of knowledge, including very hard scientific knowledge, that they had dating back decades, and that they misrepresented or concealed in their public communications. So oil industry research on climate and the effects of CO2 on climate began no later than 1958, more than 60 years ago. And by 1968, the American Petroleum Institute, the main organization for the oil majors, had a report in its hands stating that fossil fuels were by far the most likely source for the additional CO2 being seen in the atmosphere, stating that, this is a direct quote, "There seems to be no doubt that the potential damage to our environment could be severe," and that, again, the direct quote, "Significant temperature changes are almost certain to occur by the year 2000, and these could bring about climatic changes." That was 1968. And they, by 1980, they were receiving warnings from their scientists that by the middle to latter half of the 21st century, warming from fossil fuel emissions could be catastrophic. Now, if those of you who were following these issues throughout the 1980s and 1990s know that their public communications around these issues did not track the scientific evidence they were receiving internally. In 1995, one of the ExxonMobil scientists specifically told the company that, quote unquote, contrarian theories about global warming were not credible. But the very next year, Exxon CEO told the media, quote, again, "Scientific evidence remains inconclusive as to whether human activities affect global climate," almost 3 decades after the 1968 report that told them exactly otherwise. So we're here because these governments, your local governments in Boulder County, the city of Boulder, as well as San Miguel County, are trying to take the most reasonable path to plan for for the climate change impacts that are happening, rather than just sitting back and watching it happen and responding to the impacts as they occur. And we know that this is the reasonable thing to do because this is what the oil companies have done. In their own internal planning, they have planned for warming, both for planning for an ice-free Arctic and melting permafrost in their operations up there, as well as planning for sea level rise in their offshore operations. And so it's only responsible for local governments to do the same in response to these very real impacts that are happening now and will only continue to get worse in the near future. Colorado actually has experienced more warming than the global average so far. about 2.5 degrees Fahrenheit so far. And the projections from the US government, again, are that by 2050, there will be a minimum of 2.5 degrees Fahrenheit more warming in Colorado. So we're already on a path to fairly significant warming that will have severe impacts. It's going to cost money, both in terms of the extreme events, the wildfires, the droughts, the precipitation events, but also in terms of the changes that will be needed to build resilient communities to adapt to these predicted events. And again, the money for that has to come from somewhere, and we firmly believe that it should not only be the taxpayers of these communities that foot the bill. And my colleague David is going to talk a little bit more about the law in these cases, since we are in a law school, and so some of you might be interested in digging a little deeper into that.
Thank you, Marco.
Okay, well, the first thing we can do is take a look at the basic framework for these claims. And if you had to put it in a short narrative, it's that the defendants made and sold a product knowing it would cause a lot of bad things to happen. They either concealed that knowledge or affirmatively misrepresented their knowledge about that. And now that those impacts are occurring, the question is, who should pay? Should it be the taxpayers or the corporations that knew this was going to happen, sold the product, didn't tell people, misled or lied to people? And it's actually incredible. Now that the oil companies all concede that climate change is real and all concede that CO2 emissions from burning fossil fuels is the primary cause, each and every one of them has a business plan to extract, produce, and sell more fossil fuels. So it's remarkable. They're literally saying, yes, our product has done this, and our response to that is, we're going to make the problem worse for you. So that's the kind of the layman's framing of what this is. And we have claims in a complaint in court, and we have a public nuisance complaint, a public nuisance claim, a private nuisance claim, because the private nuisance is because the plaintiffs actually own their own property. City of Boulder, County of Boulder, San Miguel County actually own their own property, and like any other citizen, they have a private nuisance claim against the tortfeasors. There's a trespass claim, because the defendant's conduct is going to cause trespass by various things, be it floodwaters, be it invasive species, be it extreme storm events. So we'll have a physical trespass caused by the defendant's conduct. There's an unjust enrichment claim, which is basically you were getting rich while lying to us, and we don't think that's such a good idea. The Colorado Consumer Protection Act specifically talks about deceptive trade practices and deceptive statements made to consumers. Well, guess what? The people in Colorado heard those same statements made by the oil industry and the other parts of the fossil fuel industry, and that is exactly what this sort of statute is designed to deal with. And lastly, there's a civil conspiracy claim, which is that the defendants conspired among themselves to conceal the information about climate change. So that's the kind of the legal framework. What's really interesting is the relief that we're seeking. We do not seek any form of injunctive relief. We're not asking the court to limit production of any fossil fuel. We're not asking the court to limit the sale of any fossil fuel. No. Our position is fine. You want to make these things, you can make as much as you want, but you have to pay for the damages that it causes. So we're seeking solely a monetary remedy to compensate these local governments for these increased costs and to say, fine, if you can continue to make these things and you're going to continue to inflict damage on these plaintiffs, that's your choice, but you have to pay for that damage and that you inflict. And what happens in an economic sense, this causes the defendant to internalize the externality of climate change. So that is the basis of our seeking only monetary relief, not injunctive relief of any sort. And the other important point is some people and the defendants have made this point that what you're seeking here is some sort of national climate policy, that these local governments are trying to create climate policy for the United States. As Marco pointed out, that's not what they're doing. We're not trying to reduce the emissions. We're trying to be compensated for the actual damages that these entities have. I work in Washington a lot on national climate policy. I spend a great deal of time in Congress working on national climate policy, and this case has nothing to do with national climate policy. And as an aside, there's nothing in Washington in any national climate policy that discusses compensating local governments for the injuries that they incur. Nothing. That's not in anyone's plan for any sort of legislation that's been proposed in Congress. All right, so that's the legal framework that we have here. And there's just one other thing coming from my particular background or the background of my organization, which is for decades, conservative and libertarian economists were apoplectic at the idea that there would be regulatory responses to pollution. They hated it. Regulation, they thought, was one size fits nobody, and the best way to deal with pollution was common law tort actions. There's a whole huge amount of literature by conservative and libertarian economists saying that's the proper way we should deal with it, because then you have, instead of a regulatory agency that is subject to political pressures and regulatory capture, you have a neutral arbiter. You have a judge. You have a jury. Instead of evidence going in and rulemaking, you have actual evidence brought into court subject to cross-examination and the full judicial process. And ultimately, you're asking the defendant to pay actual damages, not what it could do or might have done, anything like that. You're going to pay the actual damages to the actual party who is injured. And so they thought this was the right way to deal with pollution until climate change came along. And then all of a sudden, all of these people fled to the exits and said, well, we said it about that, but climate change is different because we get a lot of funding from the fossil fuel industry. And I'm very, very serious about that. People, the many conservative and libertarian economists work for institutions that are largely supported by fossil fuel interests, and they have completely abandoned their principles in the face of climate change and what that would mean to their own funding. So now that I've thrown enough bombs, let's turn it over to questions.
So thanks for those bombs, and I want to back up a little bit. The premise of these remarks is that there is climate change happening and warming of the Earth, the planet, and that it's caused substantially by fossil fuels. And, Brenda, could you elaborate a bit about the science? You know, it seems like if we look at Washington, our political leaders, there's a lot of ambiguity, equivocation about first the existence of climate change, and secondly, if there is some concession that climate change exists, a questioning of whether or not it's made by a human activity, in particular the use of fossil fuels. So could you educate us a little bit, or help us maybe respond to that skepticism that we know exists, and it exists at high levels?
Sure. It's understandable given the amount of misrepresentation of the science. However, what we know is that way back in the late 1800s, there were a little bit of fossil fuels being burned. And Svante Arrhenius realized this would change the atmospheric composition of carbon dioxide, which was known to have this special property, it traps extra heat. And so what he did was he calculated, if we continued to do this, what if we, thought experiment, doubled the amount of carbon dioxide in the atmosphere? How much would that mean? It's a heat-trapping gas. Would it warm the Earth? He did the calculations back then. Since then, we've had many, many scientists looking at this with many different independent means, and we keep coming back to ballpark what he said. So we have the prediction in the 1880s. It's basic physics and chemistry. And we have detected that change because we went along that pathway. And back in I was an isotope geochemist when I was studying climate change, because you can use isotopes to reconstruct history. It tells you, it's the fingerprints. So in the atmosphere, carbon of the CO2 molecule has a lighter version and a heavier version. And there's carbon-12, carbon-13, carbon-14. Long and short of it is we can measure it, NOAA measures it, you can take samples of this, and you can see the fingerprints of fossil fuel combustion compared to trees and us and the active carbon cycle. And back in 1954 or something like that, there were oil company scientists that were contributing good science. They knew what they were doing, and we understand what's going on. So it was known, we have the fingerprints in the atmosphere, and they were doing calculations. What we've been doing over and over and over again as a scientific community is proving this principle over and over and over and over and over and over and over again in higher resolution. So now we can tell you that the number of acres burned in the United States by fires, half of it would not have been burned were it not for this level of climate change. Mm-hmm. It's real, it's here. We have to adapt to this level. We've dialed in more warming, unfortunately, and what folks are doing is let's limit the warming to a little bit warmer than now.
What would you say to those who said we had a bumper snowfall season in Colorado this year?
I would say
Other than that's good for the skiers, of course.
Yeah. I've been watching scientists looking at this, and it's very interesting. Different scientists are looking at this, and scientists are actually looking at the Siberian sector in October and looking at the snow there. And they're telling us whether we're going to have much more cold outbreaks from the Arctic into the northern hemisphere. And once the pattern sets up for the season, whether it's in parts of Europe or parts of Siberia or parts of the western part of the US, North America, the middle part of North America or the eastern part of North America, once it sets up for the winter season, tell the skiers where it's going to go. This was a good season for Colorado, but you have to plan for those drier, those less snow seasons, and you have to prepare for the extremes. We broke record cold in Chicago, which ironically is linked to the warming in the Arctic. So you have more extremes.
Right, and last year was a drought.
Exactly. That's the problem, is you have this seesawing, which is much harder for industries that want the same thing every year. You're not going to get it.
So John, you alluded to the effects of climate change, of the warming of the planet on people. And you mentioned the flooding that's occurred here. Could you elaborate on the direct effects on people here in Boulder County or in Boulder proper, the city?
Sure. I think that a couple of things that are most clear that people experience here regularly are wildfire and extreme precipitation events. Obviously, of course, drought. We're in a 19-year drought across our region in spite of the great snow year we had, which I celebrated and enjoyed and skied as much as I could. But we're still we're at the tail end potentially of a 19-year drought cycle. Those things we feel intimately. I think, not just the photos that were there. I think one of the last roads was finally reconstructed just a couple of weeks ago from those 2013 flooding events. Many people's lives here were touched. People lost their homes. People were out of their homes, evacuated across the region. We anticipate that those kind of effects are going to increase. We're going to see drier weather that will increase the impact of forest fires, increase the heat intensity of forest fires, so that will further increase the impact and what happens post-forest fire, what happens when we have extreme weather events extreme precipitation events following forest fire. All of those are things that we can expect to see more intensely and with more frequency across our whole region in the Southwest. And I will add, all of those things have been projected by scientists that are here in the region. So we can anticipate we'll see much more of that.
Yeah, I'm relatively new to Boulder, but last summer I saw over the summer I saw two mountain lions in my neighborhood in central Boulder. I heard of a few bears around the corner, around the block. And are we seeing more wildlife in the city, in the urban areas? And is that connected with climate change?
Yeah, I think last year is a great example of that, where bears in particular were coming down lower and lower, earlier and earlier, and more frequently because there was no food up higher. And that's one of the things that we would expect to see. So I think those increases in terms of encounters with wildlife, some of which can be dangerous, in the wildland-urban interface, those are just going to be more and more commonplace over time.
Right. Okay, thanks. David, I want to turn to you, and Marco, you might comment on this. You said that the lawsuit has nothing to do with climate policy. Some might think that's a little disingenuous, that in fact, especially since it's brought by Earth Rights, and Earth Rights does care about climate policy. I'd like to hear from both of you about that. You know, you're sure I understand the libertarian rationale behind that statement and how that can be sustained from the libertarian point of view that you articulated. But you know, with Earth Rights being involved and being very much at the forefront of climate change policy, I think, and not just addressing the issue through litigation. So could you maybe elaborate upon that statement a little bit? Yeah, go ahead, David, and then I'd like to hear from Mark.
Certainly. When we talk about climate policy, when we talk about a federal climate policy, we're talking about something coming out of Washington, and what comes out of Washington, and in terms of what all the proposals that we see, both regulatory proposals and legislative proposals, is how do we reduce emissions going forward? That's what we think of as climate policy. What this case is not how do we reduce the nation's emissions going forward, is how do we pay for increased road maintenance? And we're dealing with traditional local government functions. There's nothing more traditional and more local government than taking care of the roads. And in Boulder County, a lot of those roads are dirt roads. And when you have an increased number of freeze-thaw cycles, you have increased damage to those roads. This is not rocket science. Who's going to pay for that? This is a solving local government budgetary issues. This is not an attempt to reduce emissions from sectors across the economy. I've done that, and I still do that, but this is just a different thing entirely.
Mm-hmm. Marco?
Yeah, so I'd say a couple of things. With any issue that's in the courts, you could argue that it's a policy issue simply by virtue of the fact that the legislature can address that issue if they want, right? That's their prerogative, but that doesn't make it an inherently sort of policy-oriented issue, right? That doesn't mean that if you slip and fall and sue the property owner, that's an attempt to influence policy simply because the legislature could pass legislation addressing slip and fall cases, right? So what we're talking about here is whether this is by its very nature a policy-oriented issue, and we firmly believe that it's not. My organization, Earth Rights International, we don't actually do climate policy in the United States. We're very supportive of all the efforts of the folks who do. We need, an enormous number of different approaches to get a handle on this problem. But and we do a little bit of work outside the United States in other countries, focusing on some policy issues. But in the United States, we do tort law. We sue companies when they harm our clients. And that's what this case is. This is, these companies harmed these communities. They're causing them costs, and they need to pay the appropriate share of that. One thing I'll add to what Brenda said earlier about the science as well, you know, there are thousands of climate scientists doing great work, and we should be listening to all of them, but we don't even need to listen to them. All we need to listen to is the oil companies themselves, because not just in the 1960s and 1980s and 1990s with their internal scientists, but today, all the oil majors have accepted both the reality of climate change and the fact that it is caused primarily by fossil fuel activities. In a similar case to this one in California, all the oil companies, including Exxon, that were up there, accepted that the Intergovernmental Panel on Climate Change's fourth assessment represented accurate science on climate change. So for anybody out there who is a climate skeptic, you are more skeptical of these issues than the oil companies themselves. And if anybody has a greater incentive than the oil companies to, you know, be skeptical, I don't know who that is. So there's really no cause for skepticism today.
Thanks. How many of you drive an electric car? That's pretty good.
Nice.
Nice.
Very nice.
All right. I do too. I do. That means the rest of you are still using fossil fuels and got here by consuming fossil fuels. Okay. Sorry. We're in Boulder, I forget. We're in Boulder, all right. Well, I'll just stipulate that quite a few of you drove, okay, and that or drove sometime recently a combustion engine car. You know, we all consume fossil fuels. I mean, the lights that are making this possible is a result of the consumption of fossil fuels. Boulder hasn't gone all the way over to renewables yet, although that is a long-term, medium-term goal. What do you say about that? I mean, the oil companies that you're suing produce fossil fuels that we all consume. And they produce it because we consume it. Well, at least one could take that view. So how is it that they are the ones liable and not everybody collectively in some sense?
That's the kind of economic beauty of tort theory. And for the law student here, you'll understand that the tort system in the United States is created in large part to deal with the economics of injury. For the oil companies, it's very simple. Instead of calling it a gallon of oil, call it a widget. I make a widget. I sell widgets. Thousands of people buy widgets. Some of those people get hurt by the widgets. I was selling those widgets for $1, but now I'm being sued by some of those people for injuries. So what do? I raise the price of the widgets. And now everyone who buys that widget is contributing to making sure that the damage caused is compensated. So if in response to tort liability, oil companies simply raise the price of their product, it's incorporating into the price the damage caused by the product. This is elementary economics. And in that event, quite literally, everyone who drives a car, everyone who turns on the light that's powered by coal or natural gas, they are paying slightly more because they are inflicting damage on other people. In some sense, the fossil fuel producers are just a pass-through mechanism.
But might there be some argument based on equities going beyond the legal theory and the economic theory? What do you say about that, John, or any one of you?
Well, let me just say, if we're talking about equities, knowing the truth about this and lying to people for 30 years, I think is a pretty good equitable argument. So.
I'd like to hear.
Yeah, I mean, I think your argument is the perfect argument for creating good policy based on what we know today. So it was Maya Angelou who said something like, you know what you know until you know better. When you know better, do better. Well, now we know better, so let's do better in terms of the policies that we create that govern our behavior and then incentivize the things that bring real and lasting economic value to our communities and to our economy. And let's start to take action on those things that harm our communities and our economy and our health. And it seems to me this is the place where there are perfect opportunities to do that to ensure that communities can recoup the costs and citizens can recoup the costs that they have because of the damages caused, and we can craft policy that begins to address that longer term damage that we unknowingly at one point stepped into. When I bought my first VW Bug for $100, I didn't know what kind of damage that was creating. Today I do. I can take action, and we can create policies that help us do better.
So, someone might hear you and conclude that in fact, then the lawsuit is related to climate policy.
Well, I don't think in my view, it is separate from climate policy, but it is an attempt to move us in a direction where those who are responsible have to pay their share of whatever those damages are. I think policy sets us the course for the future. I think this is kind of recouping the costs of what's happened in the past.
Yeah. And so one thing that's important to point out is that we're not suggesting that these oil companies are responsible for 100% of the harm that's being caused here. All we're saying is that a Boulder County jury should be deciding how much of the problem they are responsible for based on the combination of their fossil fuel production and other activities and their knowledge and deception. That puts them significantly responsible for this. And frankly, I would stack up their responsibility against the responsibility of anyone in this room, assuming Lee Raymond is not in this room, or against my client's responsibility or almost anybody else's. I'd be happy to have that argument in front of a jury to explain why they bear responsibility that rises to the level of legal responsibility where you or I likely would not. But I'd also be remiss if I didn't point out that these communities have been doing everything in their power to reduce their carbon footprint. The city of Boulder has been engaged in a years-long fight to municipalize their energy sources so that these lights don't necessarily have to be powered by fossil fuel sources.
You might not want to get into that one. There's a big takes on that.
I'm not here to speak on that issue, but the point is that these communities have been on the sort of leading edge of trying to reduce their own footprints, but there's only so much that they can do, and they're going to face the impacts regardless. And so someone needs to pay for that. And again, I'd be happy to have the debate over whether the Exxon or Boulder is more responsible for the injuries that are occurring to this community.
Yeah. We'll take questions from the audience in the moment, but I have just a couple more questions for myself as moderator. David, you described the legal theory for the case, which is grounded in causes of action based on, as you said, torts, nuisance, trespass, and Colorado Consumer Protection Act, and perhaps something else. But focusing on that, I understand that similar theories based on tort, nuisance, similar cases based on similar theories were filed in San Francisco and New York, right, in state courts, and those were dismissed. Am I correct? Yeah.
What we have is there are about 14 cases across the United States. All except one are been brought by local governments. Two of the cases in California, all the cities and towns in California were consolidated into two separate cases. And the defendants, as is their right, when a plaintiff files a complaint in state court, a defendant can file a one-page document saying, we're taking this to federal court. And then we let the federal judge decide to keep it or send it back to state court. Two federal district court judges in the same courthouse in San Francisco looked at these issue. One said, this is obviously a series of state law questions, and it goes back to state court. The other one said, these are obviously federal issues, And I find that based on Supreme Court precedent, that as a federal issue, I'm going to dismiss those claims. And that also happened to the case brought by New York, which filed originally in federal court. So we have two district court decisions saying these are federal claims and have dismissed them. Both of those are on appeal, and we'll see what happens. We're at the beginning of what is going to be a very long legal process. This one is not we're in it for the long term, and you've got, as I said, more than a dozen cases in lots of different jurisdictions across the United States. We're going to be hearing from lots of courts, and we won't know what happened. We're at the top of the first inning. It's a long way from anything else.
Thanks. We heard from some industry representatives today and yesterday about this event, raising concern that we didn't have someone from industry on the panel. We actually had intended to have someone, but that didn't work out for reasons I won't get into. But I did get one particular email, laying out an argument that I thought was interesting, and I want to read from that and ask for you to respond. So bear with me. It's a little long, but not too long. Okay, he says, the idea of suing America's energy industry for climate change related to conduct that harms has been discredited, including by the highest court in the land. In 2011, the Supreme Court dismissed AM Electric Power versus Connecticut, or America Electric Power versus Connecticut, issuing a broad warning against the types of climate change tort suits brought by the city of Boulder. The court explained that there is, quote, no room for a parallel track, end quote, of tort litigation over climate change policy, and that setting climate change public policies were solely, quote, within the national legislative power, end quote. Further, federal judges in California and New York have similarly refused to create the type of category liability over fossil fuels sought in the Boulder case. They dismissed similar recent cases, also seeking money damages from energy companies for so-called climate change inquiries. Students attending this symposium should be educated to this case law as well as other reasons. Holding fossil fuel companies liable for climate change harms in Colorado is without any legal foundation. That is this symposium. So,
Marco?
Yeah, my pleasure. So, so the students in the audience should know that if you write a brief quoting cases like that, you're not going to have a very successful legal career, because taking a few words out of context and claiming that that's the holding of the case, when the court said that there was no room for sort of parallel tracks here, what the court was specifically talking about was regulating emissions from power plants. So it's important to not, try to make up court precedent by taking a few words out of context here, or you'll lose any sort of shred of credibility that you might have otherwise had. And in this case, AEP v. Connecticut, the court decided that what was not allowed was using federal common law of nuisance to create limits on emissions from power plants, because another federal regime, the Clean Air Act, applied to emissions from power plants, and therefore that federal statute displaced the federal common law regime. So that is the actual holding of AEP v. Connecticut. And AEP, number one, did not say anything about state law claims. In fact, it said that was a different analysis of whether the Clean Air Act would preempt claims under state law. It did not say anything about claims for monetary damages, as opposed to claims to limit emissions. And the Clean Air Act, it's a very good reason why the Clean Air Act should not preempt claims for monetary damages, because the Clean Air Act does not allow does not provide remedies, monetary remedies for these kinds of harms. So there's no reason to believe that Congress understood that it was preempting these kinds of remedies in the same way that it might have been trying to regulate emissions. If I absolutely encourage everyone to go and read AEPV Connecticut, because you'll find it does not say what they claim that it says. And if you read the New York and the San Francisco cases, what you'll find is that the judges in those cases basically took the attitude that climate change is just this big, new kind of issue. So we're not going to apply ordinary legal principles to it. We are going to basically make up new rules to say, well, it would interfere with policy making or interfere with foreign policy or something like that in order to not apply the ordinary legal rules that would otherwise apply to a pollution case. So it's those courts that are actually departing from the legal norms here. We're here saying just apply the ordinary rules. Apply the ordinary rules of Colorado law or California law or New York law. Because under those rules, these companies should be liable for the harms they are causing to these communities. And it's the companies who don't want to have that argument. They're not arguing that under Colorado law, they're not responsible for these harms. They're trying to cut off us from ever even getting to that question.
Thank you. Okay, we'll open the floor up for questions. There was a gentleman right over here, someone earlier. Okay, we'll take a question up front. Why don't you wait for there's a microphone that'll come up to you, okay?
Where we at?
And we have a number of people wanting to ask questions, so please try to keep the question short or your comments relatively short.
Assuming that your case is successful for San Miguel and Boulder counties, how do other counties get brought in and get the benefit of that? And then also, how can that get spread out to individuals, because individuals are also harmed? Thank you.
Marco?
So, we're representing these communities right now. Other communities around the country have already brought suit. There's nothing stopping other communities in Colorado from also bringing suit. So far, as David mentioned, one group of private plaintiffs has also brought suit. This is a group of shellfish. What's it?
Crabbers.
Yes, the
Federation of Fishermen's Association.
Yes,
Indigenous crab.
Pacific Coast Federation of Fishermen's Association, but it's specifically about the shellfish fisheries on the West Coast. And so some of the same legal theories could apply to private plaintiffs. Some of them are somewhat more unique to governmental entities. The public nuisance claims, the governments have a unique role in protecting the public there. But as David suggested, we're in early days of this kind of litigation. But it's possible that other communities would have claims. These communities we think are unusual in the sense, both in the efforts that they have taken to try to, mitigate their own inputs to climate change, but also in the efforts that they have taken to study and to plan for climate impacts here locally. So there's a very well-developed record of what the impacts are and what adaptation is needed and is underway in these communities. And so that's part of the reason that they are on the leading edge of this litigation.
In the back here.
So I have a science question, a causation question. If you could put together the affidavit on summary judgment or your first witness to the court past summary judgment on the science, on causation, take us through the steps. What would that person say going from the emissions for which the defendants are possible to, if you're looking at past damages, either the 2013 flood damages or future damages would be perhaps the billion-dollar cost of rearranging water infrastructure to capture the waters at a different time. So what would that scientist say? And because they're a master scientist, they're going to probably point to other people or other fields that would have something to say about this causation so you can nail them.
Who'd like to answer?
That's you.
Sure. Well, first off, we see the fossil fuel fingerprint within the atmospheric carbon dioxide. There are many independent ways to check on that, but I'm just saying you can't actually measure it. So you can get how much of the increase in heat-trapping gases. Everything flows from that. Now, the biggest impact is the carbon cycle and what's remaining in the atmosphere to trap heat day in, day out. And we know how long that carbon cycle works and which part of it will still be trapping heat for a long time. For example, 20% of what was emitted today will be trapping heat day in, day out for 800 years or longer. So going forward, if you say, forget the past, just going forward, every new, we could put a price on it, you could start calculating things just from harms that stem from that. And there are different types of harm. So for example, global mean surface temperature, 70% surface area of the Earth, that's part of global mean surface temperature, and the global mean surface temperature of this region. And that is another consequence. It's a little bit lower percentage. Global sea level rise, it's interesting in that the past harms are still playing out, because if you just look at past, it's a lower percentage for the historical sea level rise today, but it's still rising. It has a legacy because we have that heat trapping mechanism going in that's still remaining in the atmosphere, 20% of it for 800 years that was emitted in the, in the past. So let's say it was at 1960. Is it going to be 1980? Just tell the scientists when. We'll stop. We'll say, okay, we can turn off the fossil fuels from some date. You say maybe it will be 2015. Maybe it will be 2020. Let's start at 2020. We can start calculating what is the harm of that product. And you see that global sea level rise, that's why you'll see in the end of the chapter that because it's still going to rise, coastal communities can only adapt. With global emissions reductions, you're only going to shave maybe between a high emission scenario and low emission scenario, maybe 20% of the harm. The rest has got to be made up through adaptation. Whereas in global mean surface temperature here, and the amount of drought and evapotranspiration, wildfire risk, you turn off those emissions, then you reduce that harm. So let's say we can go forward. We can just calculate, because we understand the global climate system, and we know about volcanoes, we know about sunspots, they're all in the models. So all the natural stuff, no one's responsible for. The unnatural stuff, we can calculate.
We had a question down here, Sean.
All the descriptions that we hear suggest that there's a strong analogy to the tobacco legislation. So how did that play out? How was it initially, and how is this kind of paralleling what's happened?
I'll kind of handle that one. I'm going to answer that rather than Marco, because in my deep, dark past, I represented tobacco manufacturers in the cancer cases. I have a karmic burden to work off. Oddly enough, that the firm that I work for is now representing Exxon in these cases. So the answer is there are similarities. In the tobacco cases, states went to court and said, look, we have increased healthcare costs because of your product. And we don't have to deal with the issue of an individual smoker trying to prove that their cancer was caused by smoking. We have a set of 100,000 people. And even the tobacco companies admit, well, it's statistically, yes, we'll cause that. They would say, we cause some, but you can't prove it was yours, and you can't prove it was yours. When you have 100,000 people, that argument just dies. And so that led to the manufacturers understanding, once they were confronted with these mass statistical ways of looking at it and understanding that they were going to be held liable for these costs, they brokered a deal. And all the states were in, and Congress was in, and the tobacco manufacturers were in, and everyone was in. But it was interesting because the individual cases, and you can still bring, an individual smoker can still bring a case. There was nothing in any of the legislation that prevents that, but they're extremely difficult to prove. And you're going to be taking years and years and years to litigate those cases. And so I don't think there are even very many of those, if any, left in the United States.
Anybody from the panel want to add to that, Marco? Yeah? Okay. And either one of you, we have two here, so we'll take one, then the other.
In this case, is the request for damages, is it retroactive, is it going forward, or both? What's the kind of being brought up in the case?
The short answer is it's both. It's both, damages that the counties and the city have already suffered, and damages they will suffer in the future.
Right up here.
But the bulk of that is likely in the future.
Hi, I want to thank you. My question is about symptoms versus causes, and that what I'm hearing about torts is we're really kind of dealing with symptoms, where the damages, we're not getting to the causes. And we know that the sooner you solve a problem, the less expensive it is. So if we're letting it go all the way down the stream, we're going to be paying more and more and more. So my question is, how do we get to the causes?
John?
Well, that's exactly what policy is designed to do, is to limit, to change policy so that we either incentivize or mandate or somehow change the current situation and emissions patterns that we have today. There's a lot of policy and a lot of different ways to address all the different sectors where there are substantial emissions. I think I mentioned some of those earlier. We have to look at the transportation sector. So passing policies that are for zero emission vehicles, low emission vehicles, and then really ensuring that the sector undergoes a complete transformation so that you can drive your electric car from here to Denver and to La Junta and to Durango. Those are going to be critical policies that drive that ability to create that transportation infrastructure. Similarly, when you look, whether it's in the sector, whether it's in the oil and gas sector, whether it's in the utility sector, you have to look across each of those sectors and develop policies that can get to some of those emissions. In Colorado, we are pursuing legislation that is economy-wide goals for carbon emissions reductions that are consistent with the science that will drive down those emissions. So I guess I would go back to what I said during my presentation is you have to do everything. Marco said that this is going to, we're in the early days. This is going to take a long time. I thought policy was slow. It takes years. I think this climate legislation that we are hopeful will pass tomorrow, we've been working on for 4 or 5 years. That's how this moves. So I think you have to do everything.
Yeah, right there in the back.
Thank you. So do you expect then, if this is successful, for additional suits to be brought specifically for people like, do you expect additional suits to be brought by people like insurance companies, for example?
I think that the business community and insurance companies are waiting to see what happens with the initial sets of court rulings before they decide to weigh in. But are they aware of it? Yes. Do they understand climate risk better than anyone else? You bet they do. It's their business to understand that risk, and they may decide at some point that they are paying out tens of billions of dollars because of someone else's bad conduct, then by all means, I would expect them to go to court.
So one thing I'll say on insurance, which isn't precisely an answer to your question, but so there was an earlier case against Exxon brought by an Alaska Native village where they were, it was a slightly different case, but they were claiming some harms due to the melting permafrost and the need to relocate their community. And that case was not successful, but in the course of that case, some of the oil companies asked their insurers to defend the lawsuit for them, and the insurers refused, and the oil companies basically, it led to a legal fight with the insurers. And this fight ended up in the Virginia Supreme Court. And that court held that the insurers did not have to cover climate change harms because climate change was not an accident. So it's a very interesting decision. I would commend it to you if you're interested in this area of the law.
I've never read it, no.
Great. Sean, right over to your right there, right over here.
It seemed like it would.
If you can speak loud, go ahead.
To what extent is the success?
Yeah,
To what
for
extent-
webcasting, actually.
Sorry. To what extent is the success of the lawsuit dependent on the misrepresentations of the fossil fuel companies? Or asked another way, if the fossil fuel companies had posted warnings at gas pumps and other points of sale starting in 1968 about climate change, would there be a case?
My answer is that I hope there wouldn't be a case because we wouldn't be in this situation. If there's any.
People responding to the warnings, right? So
People and policymakers, you know, what the oil, yeah, what the oil companies did was take choices away from us by concealment of their knowledge. But in terms of their legal responsibility, you know, it's, in my view, the tort liability is not sort of neatly differentiated in that way. You can't say, you know, it's a clear case of these sort of three facts meaning liability and without one or not. It's a matter of degree, right? They would probably be less culpable, but there's, I think, still a very strong argument that simply for the degree of harm that they caused, even if they hadn't misrepresented, they would still be culpable. But the misrepresentations make them more responsible than they otherwise would be.
I can analogize to the cigarette cases, as a matter of fact. The Supreme Court dealt with this issue when the question of could under state law, could you sue a tobacco manufacturer and be compensated for your illness after the warning labels were put on? And the Supreme Court said yes. Yes, there are, and specifically said it about the tobacco companies' I'd use the word mendacity, but bad public statements, and public statements that were meant to undercut the warnings. And the Supreme Court said, hell yeah, Congress wasn't trying to stop that. That's bad conduct, and we will let them be held liable for that.
How about in the very back there? Yeah, one of our students.
So, understanding tort liability here, what in your mind is the perfect plaintiff in one of these cases that will kind of open up the floodgates, whether it's a single person, a community, a municipality, a state, regardless of what forum we're going to be in?
Go ahead.
I think we have the perfect plaintiffs, but I mean, and you know, that's half joking, but only half, because I do think these communities are very good plaintiffs. So, as I mentioned, the fact that they are governmental entities brings some benefits, especially in the public nuisance arena. The fact that they have done everything they can to limit their own contributions to the problem. The fact that they have studied the problem enough to know what costs they are facing in the future. Now, those costs are probably going to keep getting worse, but right now they've got a pretty good idea they're facing very substantial costs going forward. So all of these factors contribute to why we think these are very strong plaintiffs for these cases. Yeah, I think we do have very good plaintiffs for these cases.
Plus, we get to come to Boulder.
And Telluride.
Right over here in the front.
Thank you. In it just being an economic case, economic-based, it seems like the oil companies are well suited to field that problem. And how much damage can it really do to them? I mean, could it be enough to make a difference for us, the world? Number one. Number two, yes, I've personally seen that Colorado is more affected than many parts of the country or the world, in that we've been evacuated 4 times in the last 20 years, 2 of which are since the massive numbers of extensive fires and so forth. So in 2012 and 13 for the fire and flood, how do you calculate damages to human lives? The kids, the teenagers that were lost in the flood were my neighbors. Animals, shellfish, you're talking about, you mentioned shellfish, and then respiratory infections, children's leukemia, underweight infants, on and on. How do you calculate all that and also go beyond the fact that it's not just human damage? We coexist here. It's not just about humans on the planet. How do you calculate any of that? I know that's big.
There were 2 questions. Your first one was about the oil company or coal company or gas company liability. They are obviously immensely wealthy. If you took all the climate damages suffered by every community in the United States, would that overwhelm their capital? Possibly. We don't know. No one's ever tried to do those calculations, although I've been approached with an idea of let's actually kind of game this out and see what happens. So the answer is we don't know. We only have a dozen or so cases where people are making claims for damage, and in some of them they're putting numbers in there, or we can guess closely what those numbers are. And so far, we're not, even if we were to win and they were to pay those damages, it's a rounding error. It's not anything that would be significant. If everyone jumped in, that's another question. I can't really give you an answer to that. And now I'm going to punt to Marco on the second half of your question.
Well, let me say one thing about the first half of the question. So one way of looking at this is, through the lens of the social cost of carbon, which people have tried to put various numbers on. Those numbers range from the low of around $1 a ton, which is, I believe, currently being used by the federal government, to a high of somewhere around $200 a ton used by some countries in Europe. So let's take the $200 a ton estimate. That, if we sort of translate that into the cost per gallon of gasoline, and this is for the social cost of carbon globally, right? If we were to put all of these costs into the cost per gallon of gasoline, it works out to about an additional $2 a gallon. That is not world-ending for these companies. It's a whole lot of money, but that's the approximate math that this works out to. Now that's a very gross oversimplification, but it can give you some idea of the magnitudes we're talking about in terms of, all of the costs in terms of lives lost, in terms of ecosystem damages, and all of that. Courts are good at some kinds of injuries and not others. This is not a complete solution. It is not going to make these communities whole in broader sense of that word, there is no way to do that. We cannot turn back the clock on climate change, right? The only way to make, to really make these communities whole would be to actually reverse this process. And unfortunately, our scientists are telling us that's not really possible at this point. So we're talking about imperfect solutions here, but doing something is better than doing nothing. And these communities are trying to do the responsible thing, which is to plan and adapt and build resiliency, and to not put the entire cost of that onto the taxpayers.
Okay, yeah. Just one more question, right up here in the front.
Thanks. First of all, Dean, and I'd like to thank you for allowing people to stand up and ask their own questions, as opposed to having to write them down on these index cards and pass them around and have you read them. Unfortunately, that's what's being used often at the University of Colorado. My second question is, who's paying for the plaintiff's attorney? The attorneys, this litigation is very expensive, could go on for years. Sometimes courts do award plaintiffs' attorneys' fees. But now, is it being done by pro bono attorneys, or is Boulder, for example, going to spend millions of dollars pursuing this case? Thank you.
Boy, I would love to say I'd be getting millions of dollars out of this case. Marco and I are doing this pro bono, so this is cool.
Don't get me wrong, we work for nonprofits, we still draw salaries, so, but yeah, our organizations are doing this pro bono. To date, the bulk of the legal work has been done by pro bono attorneys. At a certain point in the case, if we get, when we get into the discovery process and the costs really mount, it will be necessary for attorneys from the private bar to also play a significant role. Those attorneys will be participating on a contingency fee basis. So it only costs the city of Boulder or Boulder County a percentage of what they ultimately win. And that's the way these cases are typically done, because we certainly don't want to impoverish the communities that we're trying to help through this litigation.
Yeah. Well, on that very generous note, help me thank our panelists for a terrific discussion. And I'd like to invite you all to join us for a reception right here next door at Betcher Hall. Thank you.
Thank you.